All right, hello everybody. Thank you guys for showing up. My name is Justin Stivers. I am a probate attorney, owner of the Probate law firm. Our office is based out of Miami, based out of Brickell, Miami. Though we're active throughout the state of Florida, in pretty much almost every county at this point. And we do probate, and what probate is really for your all's purposes. I know most of you all are realtors and or investors in real estate. Is probate involves transferring title in this case. So what happens is somebody passes away, somebody dies. You have to, in order to get the property in the name of their heirs or their beneficiaries, you have to go through this process called probate. And at the end of the process, the judge is going to say now who the owner is of that property, and then the property can be bought, can be sold, it can be rented out. So that's very, very basic. I'll talk a little bit more about that here in a second. So what this course, is called, more or less Probate 101 for Realtors. I want to teach you all some of the basics. Some of you all might know about probate. You might have seen this course before. You might have been through the probate process yourself, either on a professional or even possibly a personal level. So, but I want to keep it basic. I want to, my kind of goal with this is to, in the next 30 minutes or so, 30, 40 minutes or so, I want to, teach you all, give you some key definitions so that you know what probate is and what you all need to know about it, how to identify when a property is going to go through probate. So I want to, give you some examples of how you all know whether or not probate's necessary, and then just a couple quick tips on how to market for probate listings, how to find probate listings, and all of that. If you have any questions, my personal email is justin@probatefirm.com. Our website is probatefirm.com, www.probatefirm.com. Got a lot of great free resources on there. If you want, we've got actually this, you can see this is a book that I wrote on probate, basically the ultimate guide to probate in Florida. So if you can get this for free. That I can, get a PDF copy of it. If you just go to our website, you can download a copy of that for free. A lot of great, a lot of good information for you all there. So, so I started doing this course a while ago, just because I realized and saw that a lot of realtors are finding probate listings, finding probate properties, finding a property that the owner had passed away, and now it's got to go through this probate process before it can be bought or sold. Like I said, we're in South Florida, but we're active throughout the entire state of Florida. And Florida is definitely a retirement state. South Florida, a lot of, elderly community, Florida in general, but I know probably most of the realtors on here are in the South Florida, Miami, Broward, Palm Beach, Tri-Counties area. And, people come here, retire here, they pass away, but their kids are often in New York, New Jersey, other retirement place, or other cities, states in the north, and they need to go through the probate process, right? So I find that it's been very relevant, and will probably even become more and more relevant as we see baby boomer age group passing away as well. So like I said, the goal in this is just to provide you all with some basic information so you guys are familiar, so that you can identify properties that need to go through probate, and then explain a little bit about the process to your clients or potential clients. So best place to start is just talking about what probate is. And so I was talking about that a second ago, and really when you think about probate, it means that somebody has passed away. Unfortunately, there has to be a death in order for probate to occur, which is a little bit different. A lot of people think of the term what's called estate planning, writing a will, writing a trust, doing that type of stuff. All of that happens before somebody passes away. Now, when somebody passes away, we're talking about probate. So again, in your case, when it comes to real estate, if you find a property and it's owned by somebody and the owner has died, probably you're going to have to go through the probate process. And again, the process is taking that piece of real estate, going through the probate court, and at the end, the judge is going to say who the owners are, and at that point, you would be able to sell the property. And at the end, I'm going to talk about how long it takes, because I'm sure that's a question most people have. But that's basically what probate is. That's kind of the process. I know you all are likely realtors, but it could be for other things as well. Probate involves, a common example is someone passes away and they have a bank account. Maybe they have some money in a bank account and there were no other beneficiaries on the account. Often you have to go through the probate court in order to get access to those accounts. So that's another common example of when probate's necessary. An estate, excuse me, an estate, that's just a term that we use to refer to all of the things that a person had after they passed away. So let's say that the person who died, his name is John Smith. When John was alive, he owned his house, he owned his car, he had some money, he had his clothes, his jewelry, all that stuff. Now we're going to say the estate of John Smith. So estate just means everything that he had, including his debts. So if he owed money to Visa, to Home Depot, to Jackson Hospital, wherever, that's all a part of his estate. So I'll use that word estate a little bit. And then the other really important term that I want you guys to know is personal representative. So some states, for example, New York, uses the term executor. You might hear the term administrator, but they all mean the same thing. So executor, administrator, personal representative, they all mean the same thing. And for you all, that person is the most important person, because the personal representative is the one who is going to hire and select the realtor. They're the ones who's going to sign the listing agreement. They're the one who is going to sign the as-is contract. So that's the person you need to be working with, right? So usually there's one personal representative, and that's the person you need to be working with. That's the person that I work with. That's my client. My client is generally the personal representative. They're the one who is going to sign all the documents, go to court if necessary, work with me directly. And again, for you all, they're the ones who picks the realtor. And so we'll talk a little bit about who gets to be the representative, how they get to be the representative, because really that's the most important thing. And that's one of the big takeaways for you all today, hopefully, is, I talk a lot about, make sure that you, the realtor, are working with the representative, because if you're not, you're kind of wasting your time, because again, they're the ones hiring the representative, or they're the ones hiring the realtor. So, all right, so those are just a couple definitions I thought would be relevant for you all to know. And I know I said this in the beginning, but if at any point you all have questions, please just put them in the chat box, and I'll try to get to them either right then and there if it's at the relevant time, or at the end I'll make sure we try to answer all of those. So I'm going to share my screen just real quick. Okay, so how do you know when a property needs to go through probate? The easiest way is if you know that somebody has passed away, chances are probate's necessary, right? So chances are, if you know that someone has died, most likely probate's going to be necessary. It might not be, but 99% of the time it's going to be necessary. But the easiest way, if you don't know that they've died, if you don't know that the owner has died, is you look at the tax roll, the county records, and whatnot. So I know most of you all are probably in Broward, but this is an example from Miami-Dade. But same thing. This is just a printout from the county property appraiser's website. And if we look here under owner, okay, we've got Maria Pichardo, and after that we've got EST of. That EST of stands for estate of. If you see that after somebody's name, it's probably a 99.9% chance this property has to go through probate. If you see that, that means that this person, Maria Pichardo, has passed away. She's died. And before anybody can sell this property, before anyone really can, can list the property or do anything with it, you're going to have to go through the probate process. So if you see that EST of, again, that's a, no pun intended, that's a dead giveaway, that probate's going to be necessary. So that's going to be on the property appraiser's website. Now, question I get is, well, when does the property appraiser website, when does the county update those records? There's not really consensus on that. What happens is when somebody passes away, their death certificate gets prepared and recorded, not recorded, but it gets prepared by a government agency called Vital Statistics. Vital Statistics says they mail those records to the county where the person might have passed away, and then the county cross-references and will update the owner on there. However, I've seen sometimes where someone passed away several years ago and the county still doesn't update that. So, that's not 100%. You might come across one of these where the owner died a couple years ago and it doesn't have that EST of next to it. That's possible. What also happens a lot of times is the family will, so a person's primary residence in Florida, you all probably know, is called their homestead residence, meaning that's where they get a homestead exemption, they get a tax exemption. It's their primary residence, meaning they pay less property taxes. So often the kids or the family of the person who died goes to the county and they say, hey, listen, we want to continue to receive the property tax exemption, the discount. And the county will say, I'm sorry, your mom or father died. They're no longer alive. Therefore, they are no longer the owner. So they remove the homestead exemption and then they update the records themselves. If you were to go because a parent passed away and you try to tell the county that you want to pay less in taxes or keep the homestead exemption, not only will they not give you the homestead exemption, they'll remove the homestead exemption once you tell them, and then they will update this. So that's, again, I get that question a lot. That's sometimes how they know whether or not to add that EST up. So simplest way to know whether or not a probate is going to go through a property is going to go through probate is seeing that EST of. Second example, I want to show you all. So same thing, another property. We've got that Jesus Silva EST of. And then we've got another owner, Mida Silva. So this property was owned by these two. Jesus was the father, Mida was the daughter. Jesus passed away, and Mida, this was an investment property, secondary property. Mida wanted to sell the property. So she goes, hires a realtor, gets a realtor. They go through the entire process. And at the end of it, the title company says, well, did you do a probate for Jesus? And Mida's like, no, I didn't know I needed to do it. The realtor, I guess, didn't know either, didn't look at this. And so they weren't able to sell the property, and we had to do a probate for Jesus. This happens a lot of times where individuals own a piece of property together, and they own it in a way that's called tenants in common. You don't necessarily need to know that, but that's the way that if you own a property with somebody and it's owned tenants in common, it means that you own 50% and the other person owns 50%, or one-third, however it's owned. But in this case, 50-50. When Jesus died, his 50% did not go to Mida. So Jesus died and his estate kept 50% and Mida had the other 50%, which is why we had to do the probate. So a lot of times you'll see this where, and so I think I said this, but Jesus was the father, wasn't married, no other children. So Mida just kind of assumed that she was going to get the property since she was already on title and this was her dad. But unfortunately, we had to go through the probate process, and she was not happy with the realtor because they wasted all this time trying to get a list, to try to get a contract, and then they had to come back to us, and we had to do the probate process. So very important when there's multiple owners. If one of them has died, don't just assume the other person or the other people on title automatically inherit automatically receive the property. And this is really pretty common in general, but especially here in South Florida. Now, how could they have avoided this, right? So I mentioned that they own this in a way that was called joint tenants or tenants in common. One of the ways, which you all are probably familiar with, is if they had owned the property with tenants with right of survivorship, joint tenants with right of survivorship. And that's very specific language that your attorney, your real estate attorney, or your title company is going to put on the deed. It's a very simple phrase. It just says joint tenants with right of survivorship. Had that been on here, had Jesus and Maida owned this property as joint tenants with right of survivorship, the property would have, when Jesus died, his 50% would have automatically passed to Maida, and she would not have had to have done a probate for would not have had to have done a probate for Jesus. But unfortunately, that language was not on there. So if that language tends to right of survivorship, that avoids probate. If they were married, if husband and wife are both on title, and it says a married couple or a married couple, that's going to avoid probate. So if John and Jane own a piece of property together and they're married, and the deed says, John and Jane Smith, a married couple, if John were to die, Jane owns the property 100%, and she's not going to have to do a probate for John. Or if Jane dies, John wouldn't have to do it. Something to be careful of, which we see a lot of times, is especially when someone does their own deed or some of these older deeds, is someone will do a deed and it will say, John Smith, a married man, but it won't list the wife's name. I've seen where now the title company is going to require you to do a probate for John, because even though he was married and even though the deed says a married man, it doesn't list the spouse on there. So you want to, really want to make sure that you've got both names on there, and it says a married couple, or a married man and a married woman, or some sort of language. And if you have that, then you're going to avoid the probate process. So joint tenants with right of survivorship, being a married couple, and then there's another type. There's other couple of deeds that you all probably not, but your title company, your real estate attorney can do that can avoid probate. I won't go into them too much, but life estate deed, a ladybird deed, different types of deeds that when the person passes, the property automatically goes to the other person on title, and you can avoid the entire probate process. So those are good tools that we use and that you could, suggest to your clients if they're concerned about this. But what I want you guys to know from this is, if you know that one of the owner has died, we want to make sure that the property did in fact transfer to the other owners, and probate's not necessary. Because again, last thing you want to do is waste your time, waste your client's time, only to get to the closing table and find out you've got to do a probate. So something to look at. And last example that I'll share with you. So another way to avoid probate is by putting it into a trust. Okay. Having a will. So you all are probably familiar with what's called a last will and testament, right? So I do a will. I say, I want to leave my property to my children. If I do that, my children would at some point get the property. However, they're going to have to hire an attorney and go through the probate process. I'm going to have to or whoever's doing it is going to have to take the will to court. The judge is going to have to approve it, go through the entire process. You pay the fees and all of that. And at the end of the process, the kids would become the owners. So a will by itself does not avoid probate. And that's a big misconception, a big misunderstanding people have. They'll call me and say, hey, listen, I have a will, but the county said, that I've got to go through a probate process and I've got to hire a probate attorney. Unfortunately for that person, it's true. A will does not avoid probate. However, having a trust does in fact avoid probate. So this is an example here where Karen S. Rodman, the TRS stands for trust. Okay. BEN stands for beneficiary. So in this case, Karen did a trust. She did a actual, trust document, which says, what do I want to happen with my property after I die? And then she did a new deed and she transferred the property from herself. She owned the property before, and now she did a new deed and the trust owns the property. That's a very important step that a lot of people miss, is they create the trust, but they actually don't do the deed. And in order to avoid probate, you've got to do a new deed. So in this case, Karen created a trust. She made Karen Jr., Karen Rodman, a beneficiary, so that when Karen Sr. passes away, Karen Jr. automatically gets the property, and she's not going to have to go through the probate process. The county is going to, when we do this, we send a copy of the trust to the county. They have records of it. And so Karen Jr. would just automatically get the property, and she's not going to have to do the probate process. So very useful tool. Trusts are great. I get a lot of questions about those, how to do them, who should do them. Arguably, if one of your concerns, either you personally or one of your clients, if one of the concerns is how do we avoid probate so that, my kids don't have to go through it, and there's a smooth transition and they don't have to pay an attorney and all of that, trusts are a really good option. And they avoid probate process. They avoid the probate. So a good option. Remember, if you see that this EST of, pretty good indication that probate's going to be necessary. If you see a couple owners and one of them has passed away, then again, you want to make sure, find out how they own the property, have your attorney look into it, find out how they own the property, and see if you need to do a probate before you just kind of jump into it. So that's the best way. That's probably the best ways to know whether or not probate is necessary. So Sylvia, you asked what is what is estate planning. I was just saying that when you use the term estate planning, we're talking about a will, we're talking about a trust. A person is alive when they do the estate planning, as opposed to having passed away. Now we're doing the probate. So estate planning happens before someone dies. Probate happens after somebody dies. All right. So let's talk a little bit about, let's say that we've determined that probate's necessary. Okay. So, and I say we, but you've done your due diligence. You've looked at the title. You've probably asked your attorney, your probate attorney, hey, does this look like probate's necessary? Or you now know that probate's necessary. Okay. Like I said, 20 minutes ago, 15 minutes ago, the person who's going to hire the realtor, at this point, we're just going to assume that the probate hasn't started. So this is a cold listing. Maybe you just found door knocking or a mailer, or someone calls you or whatnot, and they haven't hired a realtor yet. We want to make sure that you are speaking with the person who is going to become the personal representative, because the personal representative is the person authorized to sign the listing agreement, sign the as-is contract, and hire the realtor in general. So how do we do that? Very, very important. The personal representative is named by the court. Just because a person does a will and the will says, I name John as my personal representative, we still have to take that will to the court, give it to the judge. The judge has to prove it. There's a process. And at the end of it, the judge hopefully is going to say, John, you are the personal representative. But just because you have a client who comes to you and they say, listen, I'm the only child. My dad died. He wasn't married. He had a will. He named me as the representative. That all sounds good and that all might be true, but that doesn't mean that person is in fact going to be the representative. And I'll just give you a short example. I've had a case, well, several cases, but I've had a case where, in this case, let's call him John. John had a will from his mom. The mom said that John is the representative, and it looked like he would be the representative. However, that will was done in 2005. John has a sister. named Jane. Jane's mom did a will, another will that named Jane as the representative. And her will was done in 1995, okay? Or I'm making up these numbers, but the facts more or less are true. There was a first will that was done, and a second will was done about 10 years later, and the wills named different representatives. Well, we've argued before that the will that was done 10 years later could not have been valid because the person who made it, the mom who made it, had Alzheimer's or she had dementia. And so the person she made the representative, coerced her, tricked her, into signing that will, and she didn't know what she was doing. So we have to go to court, and we have to submit both wills to the judge. And then the judge, after hearing evidence and all of that, is going to say who the representative is. So I see a lot of times where, people can be convincing, and if you just don't know, you don't know, and you think that you're working with the representative, but just know in the back of your mind, that representative is going to be named by the court. The court actually has to sign a piece of paper. It's called Order Appointing Personal Representative. So until you have that paper, you don't have a representative. So just, again, something to keep in mind. All right, so let's say now we've determined probate's necessary. How are we going to determine, whether or not this person's going to be the representative? Because, again, you might just not know. Let's say there's no attorney involved, you just got a call, you drive over to their house, and you're trying to figure out, is this person going to be the representative? Ultimately, you are not going to make the determination whether or not they're the representative or should be the representative, because that's really probably outside of your scope, and we don't want you doing anything close to making legal determinations. So Sylvia, your question, can you ask for the piece of paper? Yeah, you could. Sure, if you want, if you felt comfortable, like you knew what that document was. But if I'm you, I'm probably not gonna, if I'm the realtor, I probably want to have my attorney do it, because that's really a legal determination. So I probably wouldn't want you doing it yourself. But what I would do, again, you can lay the groundwork for when you bring in an attorney, or for when the client hires an attorney, or for, just to have inform the client as well. What you probably want to do is go over there, and I recommend that you ask 2 questions of this person. Ask them if they have a last will and testament, right? So we talked about what a will is. And we talked about, a will says what happens with your stuff after, and it's probably going to name who the representative is. You want to ask them if they have a will, because if, let's say that you're speaking with the son, and the son was the only child, and the son was taking care of dad, and he tells you, listen, no, my dad didn't have any other friends, no other family. I'm 100% sure, like, this is going to be my, this is my property. My dad told me, he swore I'm going to get it. And you ask him, oh, did your dad have a will? Yeah, he had a will. He had a will. He did it, but he did it 15, 20 years ago. Okay. And if the will says dad leaves the property to his, longtime secret girlfriend, which happens, then the son is probably not going to be able to hire you as the realtor, because it's probably going to be the girlfriend, and the girlfriend is the one who is going to hire the realtor and sell the property. So you want to find out. And again, I'm not telling you to read the will, interpret the will and everything. This is just kind of, general knowledge that I think is useful, that, again, I always tell realtors, listen, you've got 60,000 other competitors in the South Florida market. If you can just ask some questions that other realtors aren't even asking, don't even know to ask, you're going to stand out from a lot of your competition. So just by asking if there's a will and all of that, you're leaps and bounds above other realtors. So we want to ask if there was a will. And then second, we want to ask them if they have a copy of it. And the reason is, sometimes every once in a while, I'll get a call from somebody and they'll say, hey, listen, my dad died 20 years ago. And he told me I get the house. Okay, great. Do you have a copy of the will? No, he wrote it down, but I'm not sure where it's at. Well, there's not a master database that I or any attorney can go to try to find a will. Wills are pieces of paper. For example, when we draft wills, when we do a will, I keep the electronic copy and I give the original back to the client. The client will then, I say, keep it somewhere safe. Don't put it in a safety deposit box because then nobody can get it, but keep it somewhere safe. But there's not a, will.com that I can go to find out if everybody in the world has ever done a will. It just doesn't exist. I can use a copy, but if I don't need to have a copy, it makes it difficult. Wills do not get, like, Sylvia, you're asking, do wills get recorded with a court? Wills don't necessarily, once we open the probate, they do. If there is a will, I have to give it to the court. But before that, no. So, before, like, if somebody passes away, I can't go to the Broward County Courthouse and say, hey, this person died, let me see if they have a will. It's not really done like that. So we want to find out if they have a copy. If they don't have a copy, chances are we're not going to be able to go by whatever that will may or may not have said. So 2 questions. Well, part 1 and 1A. Did they have a will, and can we get a copy of it? Second question I want to ask is, what's your relationship to the person who died? Was this your mom? Was this your dad? Was this your brother? Was this your sister, cousin? Who was it? Who was it that passed away? Reason is, in Florida, if there is no will, so if someone dies and there is no will, there's a hierarchy of who's going to get what. First, it's going to be the spouse. If there is no spouse, then it's going to be the children. If there are no children, then it's going to be the parents. And you just keep going on and on and on, until you get to second, third, fourth, fifth cousins. That happens sometimes where, there was no immediate family member, or it's so old that, you're going way out into distant cousins. But most of the time, there's going to be a brother, a sister, maybe a parent, a cousin, or something like that. If that's the case, then if you're speaking with a third cousin, chances are he or she is not going to be the representative, because there's probably going to be a brother or a sister or somebody's involved. Even if we can't find them, if we know that there was a brother or a sister, and they just tell me, yeah, well, he left home 20 years ago, we can't find him, he's a drug addict, he's homeless, which happens. I still have to try to find him. We still have to find him, and we have to notify him. And it's a pain, because then and it costs money, because we have to hire a private investigator and do a bunch of stuff. But for you all to know, just kind of, again, we're in this stage, you're trying to figure out if this person's going to be the person who's going to be the representative who can hire you and sell the property and everything. We want to, the closer in relationship, so a child, a spouse, a parent, a brother, a sister, that's good. If we're getting to second and third and fourth cousins, a little bit different. So, Sylvia, another good question. So what if the son thinks he will get the property, but dad did a will later on and left everything to be, I don't know what the next thing is, but so doesn't matter what the son thought. If dad did a will and left the property to somebody else, the will controls right there. All right, so I only got maybe 5-10 minutes left, but I want to talk a little bit about the process itself. So how long does the probate process take? That's a big question people have. There's 2 different situations, 2 different scenarios, and it really depends on when the person died versus and when the probate was started. So most commonly, it's more common that when somebody dies, most of our clients come to us about 2 to 3 months after the person died, right? The first month, admittedly, or they're upset, they're grieving, they're dealing with the funeral, they're dealing, just stuff that has to happen. And then month 2 or month 3, they usually come to us and they realize they need to do a probate. If the person died within 2 years, so the person died in 2019 and we're doing the probate in 2020, it's probably going to take about 7 to 8 months from start to finish. The first 30 days, it takes us about 30 days to get the representative appointed. right? So it's going to take on average 30 to 45 days for us to go to the court and get that order appointing personal representative signed by the judge, about 30 to 45 days. Then after that happens, after the representative is appointed, there's what's called a creditor period that lasts 90 days. So we have to wait those 90-day period for anybody to come forward and tell me, the attorney, hey, John who died, he owed Visa $1,000. He owed Baptist Hospital $15,000, whatever it is. Even if he didn't owe any money, even if he, everything was current, paid all of his debts off, we still have to wait that 90 days. So it took 1 month to get the representative appointed. Then it took 30, 60, 90, another 3 months. So now we're at the end of month 4 for that creditor period to expire. And now in month 5, we're able to ask the court to allow us to sell the property or transfer the property. So it's usually about 6 months. 5 would be the quickest possible, but usually closer to that 6-month mark, we can sell the property. And then doesn't matter for you all, but then we still have to do some of our stuff in the probate. So it's probably going to be another month or 2 before it's officially closed. Most probates that we do average about 7 months, 6 to 8 months more or less. But for you all to sell the property, it's going to be about 6 months. If the person died within 2 years. If the person died more than 2 years ago, so let's say that we're in 2020 right now and the person died in 2017, we don't have to worry about that creditor period. There's a limitation on when those creditors can file a claim. So it's still going to take us about 30 days to get the representative appointed. So still 1 month. Month 2, now we can ask the court to transfer the property or to sell the property or do what we need to do. So it's probably closer to 3 months. So I would say if the person died more than 2 years ago, it's probably about 3 months for your all's purpose of being able to sell the property. If the person died recently within 2 years, then it's probably going to be a little bit longer, probably going to be 6 months, more or less. So that's just to give you an idea. Now, we do a lot of these, and that's the average, but there's certainly times when that average can be thrown off. If we've got siblings who are fighting, if we've got foreigners that we're trying to locate in different countries, if we've got people, if we've got multiple wills, if, a bunch of different stuff like that, that can obviously, extend the time significantly. But anyways, it's between when the person died. If they died more than 2 years ago, 3 months. If they died within 2 years, probably 6 months. Last, kind of substantive stuff, before we kind of wrap up. So if you guys have any questions, please put them into the chat box. But the contract, the as-is contract, needs to be signed by the personal representative. That's why I was, kind of harping on that. And a theme of this is, how important the representative is. He or she needs to sign it as the personal representative. So when you have that contract, the seller is going to be John Smith as the personal representative. That's very important. Don't list a property until you have the representative appointed. If tomorrow someone comes to you and they say, hey, my mom died, I want to sell this property, don't put it on the MLS, don't put door hangers, don't put signs in the yard or anything. You need to wait until the representative is appointed, because again, going back to that example of 2 wills, if you start listing the property and you find out that your client is actually not going to be the representative, now I don't know if you'll get in trouble necessarily, but you've wasted time at a minimum, because someone else is going to be the representative and they're going to list it. So, so wait until the representative is appointed. All right, and just a couple quick things. Obviously finding listings, probably important to you all. One of the things you can do is you can buy lists. So you can find find somebody who will sell, or you can purchase the list of personal representatives, people who have who filed probates, who probates are open. You can get their contact information. You can reach out to the personal representative directly, and or the attorney who's handling it. My advice for you on that is that if you are in fact going to reach out to the representative, you probably want to, don't come in, too aggressive. This person's probably just lost a parent, lost a loved one. So you want to make it a little bit more soft, say, hey, listen, very sorry for your loss. I'm not sure if you've got anyone helping you with this. I've got a team. We're very experienced in probate. We can help you clean out the house. Whatever your spiel might be. But that's an opportunity. The other thing is, reach out to other probate attorneys. Most probate attorneys, are going to have a lot of listings that they work with. For example, we do about 200, 250 of these every year. And a lot of them have real estate in them. Now, when we're able to, we like to refer out because we like to work with the realtors that we know, like, and trust. Sometimes the clients don't want to sell, or sometimes they have their own realtors, or they are a realtor, or whatever. But I'm one of many, many probate attorneys. So if you reach out to other probate attorneys, build a relationship, they can be potentially a good referral source. And you can also search public records, right? So most of this information is public records, and you can find out which properties are owned by estates, which might need probate assistance. And a lot of times these clients don't even know they need to do probate. Like that example that I gave you in the very beginning with Maida, she didn't even know that probate was necessary, right? They don't even know. So you might find an opportunity there, and you're educating the client, which they'll be appreciative about, because they'll realize, I'm glad I didn't spend all this time trying to list and sell this property. So that's an opportunity as well. So I'm gonna put my email in the chat box, justin@probatefirm.com. If you all have any questions, or if you want a copy of this recording, I will send you all the link so that you can go back and watch if you had to leave early, or have any questions or anything. Send me emails directly, or like I said, go to our website is probatefirm.com. We got a lot of good information out there, and phone numbers in the chat box as well. Like I said, you can get a copy of my book on probate, which is a good resource for you guys. You can download it for free from the website. And if I see Donna's on there. So Donna, thank you for inviting me to come here. And I don't see any other questions. So hope you guys have a great afternoon, and we'll talk to you later. Thank you, guys.